presiding officer, who's Munanura Ivan. And the point I'm building here is that there is no way that affidavit of Munanura can cover for the returning officer because the two officers have different statuses.
That's why I'm saying, in the event we find that the affidavit of the second and third respondent does not cover the third respondent, then it would remain for only Munanura.
Yes, Your Worship. And my submission right now is how I'm showing how it does not cover.
No. You don't even need to go there. The question is it competent before court or no?
It is not.
Basically.
And Your Worship, I'm relying on these sections. I request the court puts them on record. That the affidavit of Munanura Ivan cannot be deposited in support of the statutory roles of the third respondent under sections.
No, like I've told you, that is now the effect of the third respondent. For example, if this court finds that the third respondent did not put in an affidavit in reply, then in the substantive application, for example, you would raise that up in your submissions. And it is also up to him to respond to them, because for you keep on insisting that area was not defended.
Yes, sir.
Yes. And that will come up in the main or substantive application.
I'm also glad, Your Worship. You also refer to section 14, subsection 3. Your Worship, I have to differentiate these sections and whether they fall on the effect or the cause, but you were referred to section 14.
They're also referring to the effect.
Yes, Your Worship.
Because at least to me, over the issue there, because the issue was that affidavit competent. And he told us the affidavit we have, much as it was sworn by one person for two people, it seems to only represent one person. It's not covering
most of it.
But however, the evidence of Munanura, according to him, covers.
Most of it.
So he seems to say we don't have the affidavit of the third respondent on record.
Most of that. Your Worship, now I'm moving on to the sections that he relied on. For the sections, the particular sections he relied on in support of his affidavit. To differentiate them and submit that they are not applicable. The first section is section 14, subsection.
And why I'm not even going to write, because I've told you, because I'm looking at what you raised. The issue was whether it is competent or not competent. So the sections is raising, we on the effect, and we are all saying the effect will come in the main.
Yes, can I take from the court that the court is not relying on sections 14 and sections
No. What I'm saying is, because I will go by the PO you raised, and that is what I want to determine. And the PO is not on the effect.
If the court is relying on those sections, then it is fair that I rejoin on them.
For example, why should I rely on the sections that are taking me to the effect? Yet here I'm looking at whether I should strike out the affidavit in respect to the third respondent.
The judge may request to be comforted by the court that the court is not relying on sections 14, sections 48 of the ECA, the Reformations Act, as cited by counsel. If the court gives me that comfort, then
maybe my simple question is, are they applicable in respect to the competency of whether we have the...
My submission is that they are not, and that's what I request to demonstrate.
Go ahead.
So section 14, Your Worship, for brevity of the record, I will read it. Section 14 subsection 3 reads, the commission may also, where necessary, assume the performance of any function of an election officer under any law. This section is inapplicable to the extent that Ivan Munanura, the deponent, is not the commission. If you are to rely on this section to say that the affidavit on record was deponed pursuant to this section, then it should have been a member of the commission. Because the same law defines who the commission is. Because this law says the commission may, where necessary, assume the performance of any function of an election officer under any law. The commission, for example, can assume the duties of a returning officer or the duties of a presiding officer, but not the vice versa. In this case, a presiding officer cannot assume functions of a returning officer. So to that extent, this section is totally inapplicable. The section, the Act defines a commission as that established under Article 60. Article 60 of the Constitution.
So I got you so well. However, you're
I am also
even going overboard.
The court did not give me the comfort that he was not going to rely on those sections.
Why you saying so? Are the sections material to your PO you raised? Because your PO was on the competency of the one person swearing for himself and on the behalf of another person.
Your worship, and
Yes.
I agree with the court entirely. But I am not sure how the court is going to interpret
Because now,
those
for example, if I interpreted them, what would be the effect? Because
The
basically
effect-
I'm addressing the PO, his was a reply to your PO, was not creating the new
Your worship and submission, at least that section doesn't apply. That's why
to the PO you raised.
Yes.
Yes, that I appreciated long ago.
Your worship, I'm also submitting that section 48.
Because at least from what I've appreciated is this. The third respondent did not swear an affidavit towards the claims in the application.
Most of that, Your worship.
That is not disputed. They don't dispute that fact.
Your worship, last on that one.
But however, he's saying he was substituted by Munanora.
Your Honor, I think I need to make further clarification. One, by my...
It's clarification, it's clarification. You need to tell someone. First,
Okay,
sit down,
just
let
briefly,
someone
let
finish.
me
I
get.
need to be guided on what he's going to do.
Can you
Am
sit
I
down?
going
He says
to
it.
Rejoin the game?
No, off record.
Off record,
Yes.
most of that.
Your Honor,
Off
I'm
record,
giving
most
a
of that.
clarification. Counsel for the applicant is emphasizing that court should agree with me. Court must agree with me. Court must decide in my favor. If I don't see court agreeing with me, I'm not comfortable. This is a court of justice. This is a court which is investigating the matter and is going to make an independent decision. It is not in order for counsel to insist that court should give him comfort that he will. He's
Okay,
that's number one.
basically he wanted to reply to the sections and I was telling him it was not necessary taking me that direction. Much as I let you raise them,
Yes,
you get me? Because the issue was basically simple. Did Heavy Runji or the
Chong
returning officer file
File an-
a response to the allegations in the application, and we seem to say no.
I am saying it was not necessary. Why? Under these
Exactly,
reasons.
exactly.
of
That
the
is what I
sufficiency.
was echoing.
And
Yes.
when counsel says that the electoral process, it flows like a river, that goes to a petition. And this application is based on a recount. It's
Because
not-
basically the issue was, did she put in an affidavit in reply or no? Basically that. As to the impact, we shall address that in the main application, for example.
Much of
Basically. Okay, you can, if you're rejoining for another issues, please go ahead.
Your worship, I'm most obliged with the court's guidance. Your worship, there was the first respondent's submission on the affidavit of Mhunza Julia, Nachiranda, and Alan John suffering this. Yes, it was submitted that affidavits, preparation of affidavits is a matter for the lawyers, and that duplicity was a matter of the draftsman. Your worship, affidavits are not pleadings.
They are not?
Pleadings. Affidavits is evidence. Which book record I know is not an area That's why Your Worship affidavits are made on oath. And they are owned by the deponent as their wives. So it's not a matter of mere draftsmanship.
Understand?
My late friend relied on a decision by the Court of Appeal whose copy he did not have.
We
Maybe the other, but with leave of course, counsel.
Most of that,
Okay.
Your Worship.
Maybe the other angle area he raised on the same, he said that it was very normal for different deponents giving the same evidence in similar manner over the same facts, same event. When he said it was very, very normal. That was the other argument.
Your Worship, I'm going to come to that.
Okay.
But before I leave that point I was making,
You want to address the authority?
yeah, I still refer the court to the decision of Muyanja on the seriousness and the importance of affidavits in election matters.
But to me, over that area, I think, because basically it seems to be on facts, not even law. Because why am I saying so? In your submission, you said it was just natural that the same people or different people cannot say the same or give the same evidence that is similar over the same facts. You wait. And he said, no, it was very normal. So basically, we seem to be applying common sense. He said that according to him, it is normal. According to you, naturally it is not common. But nobody seems to admit that whatever all these people said was not true.
Maybe my land friend did not pick my example.
That's why you don't want us to take so much time on that.
The Worship I'm submitting on it. My submission is not that the evidence is similar. Because that would be okay.
Actually,
but I'm
same.
saying it's the same wording. I'm particular with my diction and the choice.
Exactly, and what I'm trying to say is when I asked you the why you say it is not common or it's not possible, you said it is natural. That naturally it is not possible for different people speaking out the same language over the same facts. And with him, he told the court, no, it is normal. And I'm saying,
can I come to that? Because I was addressing his submission about that this is just a matter of the draftsman. I have not yet reached that. I'm still in the submission that this is a matter of a draftsman. It was a lawyer's mistake, and yeah, okay, that it's a matter of whoever drafted the affidavit.
Because it would have been different if he had admitted that, okay, the evidence given by the deponents to do with those paragraphs that are very similar was not actually true. But he seemed to justify the same to say it is normal, very normal. And you seem to say it is natural, that it is not possible. So I don't want us to dwell so much on that because nobody has an authority. It is not based on science, not based on law, but on one's perspective. So basically, it was your opinion, it was his opinion. It is normal, it is natural. So
most obliged,
yeah.
Your Worship. Your Worship, then he referred to the authority of Tuku Francis. Tuku Francis versus Elfas Ndamage about what he termed, and from this decision, that affidavits must be drafted with precision. That was his submission. Your Worship, our submission on that is that yes, it's true. Affidavits must be drafted with precision, following the precise words as stated by the witnesses. And our rejoinder on that is that his reliance on that authority is inconsistent with his submission, blaming the error on the draftsmanship.
No, maybe what was the error? What was the error?
Because he said that's a matter of the draftsman.
Okay, now what is the error there? What error did he admit?
You see, Your Worship, you have two arguments which are mutually exclusive. You cannot.
Okay, my
reconcile.
advice would be don't dwell so much on that, because in any case the respondent did not admit the fact that the similar paragraphs were not true paragraphs. That is not admitted. If it was admitted, then we'll discuss all of that. But he seems to insist that much as they are similar, it is very normal for such deponents to be similar.
Your Worship,
similar assertions are valid.
you worship.
That's, and to you, your argument was it is not possible.
Yes, Your Worship, that was my main submission.
And
I'm now in the rejoinder. And in the rejoinder, I am saying that the authority relied on actually works against the submission of counsel. The authority relied on requires precision in drafting affidavits. So you have to record as precise and as nearly as possible, the words used by the witness. Whether or not it's normal for the three witnesses to talk to the draftsman using the same words, using the same order at two different points, also appear before a commissioner, take oath, I will leave that to the court.
Thank you. Okay.
Then, my dear friend Mr. Wasariwa submitted that affidavits are restricted to the knowledge and belief. And a submission on that is that evidence on belief in affidavits is only in interlocutor applications. If a matter adducing of evidence is restricted to affidavits like the instant application, a deponent cannot depone on matters of belief.
On matters of?
Belief. Because beliefs are only restricted to interlocutor applications. This is not an interlocutor application. This is a suit. And Your Worship, where do you find that? Order 19, Rule 3. The same procedure.
Did you appreciate the context in which he raised that?
Yes, he was relying on a decision which is...
No, from the facts, from the pleadings.
From the pleadings...
Because, yes, he got that kind of argument while addressing a certain area in the pleadings.
He was addressing the area of the use of we.
No. He was addressing the failure of Collins to attach the documentary evidence to do with accreditation by the EC. To say,
maybe
Ivan, sorry. To say that affidavits are limited to what you know. So he seemed to say on attaching documents or no, it is immaterial. It is important.
He said that affidavits are limited to knowledge or belief of the rest. My submission, I'm attacking the belief.
Okay, now, like I was bringing you on board, he raised the same argument in respect to Ivan failing to attach.
Yes, Your Worship, that's what I say.
Okay, go ahead.
So my submission on that is that in an application of this nature, where the only mode of adducing evidence is by way of affidavits, matters are strictly limited to knowledge but not belief.
Are limited to?
To personal knowledge of a deponent.
To personal?
Knowledge.
Because you see, in simple terms, it is simple to say that if you don't have that attachment, is your affidavit defective by merely not having the document? And they were saying no, because affidavits are limited to what you know, not the attachments.
Yes, my lord. Because now the argument that deponent A believes that this
From what they
was
saw,
done, the argument that a deponent A believes that this was done is not the kind of evidence a deponent can depone in an application of this nature. That's what I'm saying.
So basically, are you disputing the fact that if there is no document, the affidavit is defective? Are you still arguing that way or no? Because his argument was the affidavit is not defective by merely lacking an attachment. And basically that was his argument. So I don't know, in a rejoinder, do you agree with him that merely failing to attach a document doesn't make an affidavit effective?
No, Your Worship, I do not agree with him. Because you see, now that it calls for speculation. But Your Worship, maybe we can go back and check the record. He was referring to the affidavit of Alan on the use of we. And he was saying provided he was present and what?
The we?
Yes, the affidavit of Alan relating with the we.
Your Honor, maybe as an office of court, and I want to invite my colleague to be attentive, because it is going to help me. This is the first time I'm seeing an applicant who doesn't want the application to be heard through prolonged appeals. But Your Honor, for the record, when I was making reference to the affidavit of Alan, I even mentioned paragraph 2.
Yes, or not here.
Yes, paragraph 2. I was very specific that paragraph which they attacked, and I think the record can bear me out.
Well, that's what I reported.
Exactly. So, Council, just be attentive. I know it's late, past lunchtime.
We are
we might be getting tired.
But
that's
I
exactly what I said. And two,
take down your POs, they make their reply, then we can break off for that. That's what
Actually, Your Worship, I'm looking at the issue of
no,
time.
he has made the clarification.
No, what I was
Finish
looking
it.
you are saying we take down the PO, then they make a reply, we break
Then we break off.
I was
go for lunch,
suggesting,
I come
Your
out.
Worship, if the timelines are to be, if you are going to meet the time and have this matter finished, we could, I'm looking at making it easier for all of us. We can take, there is only one PO relating the affidavit and rejoinder. The other POs can be part of our reply to the application. So that, depending, the court can guide us. If it wants first determine POs and then we determine that the application or not, it can go that line. But if court is going to reserve ruling on the POs to be given at the same time with ruling on the application, then we can let them we can raise one PO about the affidavit and rejoinder. Then we let them raise the application. When we are making our answer to it, we also raise our POs. Then in their rejoinder,
Now, that
I
will
don't.
depend. If your POs are on points of facts, then I have no problem.
The
But
points
points
of
of law, definitely they supersede.
Okay, then,
But my take was, they finish up with their
then
rejoinder.
we begin ours.
You raise your POs, they reply, we go for lunch.
Yes.
I write my ruling over all the POs, then we get to know the way forward. Because my worry is what happens if you're going to submit on affidavits of some deponents when we are going to strike them off, for example. Yes, it would be a wastage of time. So you can finish up with your rejoinder. If people raise their POs, they respond, then we break up for lunch. On coming back, I deliver a ruling on the points of law raised, then we can now look into the application. If it will still be existing anyway.
You should, we are most obliged. We only need about 3 minutes.
Go ahead.
My land friend can sum up.
So now, for your correction, for the record, he raised the argument of limiting a deponent to what they know and believe in when he was addressing the issue of Alan failing to attach the document to do with the accreditation.
Yes, and you worship my submission is that the affidavit of Alan can only be relied on by this court to the extent that he deposes facts in his personal knowledge. The facts based on belief cannot be relied on. Whether he
Now, like which facts that are based on belief?
You worship the entire affidavit of Alan. We had about 3 points that we raised. We had 3 points that we raised.
Because remember, for information, you are the rejoinder.
Because
you're only responding to
I'm being taken back.
I remember, like I'm saying, you're only responding to his submissions. And I've told you in his submissions, he was justifying the absence of the accreditation to say it is not fatal to an affidavit, because in the rules governing an affidavit or drafting an affidavit, basically they are looking at the content you know. So the attachment to him, he seems to say, is not fatal to the affidavit of Alan. Basically, that is what he was saying. So in your response, what do you say about that? Is it fatal for him not to attach the accreditation document, or it is not fatal?
Your Worship, it is fatal because he is deponing based on capacity. He is deponing basing on the capacity
Go on.
of having knowledge as an accredited observer. And if he does not attach the proof of him having assumed that capacity, it renders the affidavit.
Your Worship, correction. We have not in anywhere talked about anyone being an observer here.
Okay,
An observer is his own word.
You can just see. Now let me ask.
You should say in paragraph 2 that he's accredited by
Not observer.
Let me ask. What if he had just mentioned having observed the elections without mentioning the accreditation? Does it make the affidavit defective?
There, Your Worship, it would be different. He would be deponing it in a different capacity. But if he's to depon an affidavit as an accredited person by the second respondent, then he needs to attach that. He would have also stated under what right he's deponing that affidavit.
Okay.
So, Your Worship, I will invite my land friend to sum up the other 3 areas in a brief review.
So in simple terms, you seem to say he has not adduced evidence to prove that he was even there. Is that what you're trying to say?
That the affidavit does not demonstrate capacity within which it was defined, and that's the requirement of the yes.
Okay.
Your Worship, I will start from the affidavit.
This is counsel.
For the record, Grace Giano.
Enoch, yes.
I will start from the affidavit of Nesco Alan. Your worship, it is true that any person in possession of facts relating to the dispute before court,
Any person?
any person in possession of facts relating to the dispute before court can put on an affidavit under Order 19 of the Civil Procedure Rules. However, where a person comes in a certain capacity, if evidence which was gathered acting in that capacity, then there must be proof attached on the affidavit of that capacity.
Okay.
The gist of our point of law was that in paragraph 2, Mr. Alan is deponing this affidavit as a person who is accredited by the Electoral Commission. And you are saying accreditation of people to carry out this duty is a matter of law.
Okay.
Now, since there's no letter proving that capacity, the entire affidavit collapses. That's one.
Now that is by law, by what exactly? Which authority?
That is under section 16 of the Electoral Commission Act.
What does it say?
EC accredits people to...
No, I mean for it to collapse because it did not have the attachment.
It means the entire affidavit is incompetent. That is my submission. Yes.
Do you have an authority for the cemetery?
I don't have any. I know, but I don't have any of it.
Doesn't have.
Okay.
Yeah. Then, still on that affidavit, Your Worship, in election-related disputes, there are two modes of adducing evidence. The first is by affidavit evidence. If it so happens that your affidavit is deficient in material facts, you as counsel representing that party or deponent can call that deponent, put that deponent on oath, file the material defects in the affidavit. But you as counsel at the bar, you cannot raise material facts to fill the affidavit.
On the way.
Yes, Your Worship.
So you're saying counsel
So
are
under
not competent.
paragraph 5, the objection which we raised has not been in any way challenged.
So you're saying on the way.
On the way which is indicated in paragraph 5 of the affidavit by Mr. Alan, our objections have not been rebutted.
So you're saying counsel for the first respondent do not have the capacity.
What counsel for the first respondent submitted was evidence at the bar. That procedure is unknown in the common law jurisdiction, Your Worship. have followed the proper procedure of bringing that information before court report, but not explaining how video failed because it's not a deponent, it's counsel. So we invite court to reject all his submissions regarding the issue of video evidence under paragraph 5. That
So
is
basically, you're moving court to strike out the way the
to
paragraph
reject
was
those
written.
submissions because that is evidence.
Made by counsel. Okay.
Yes, made by counsel specifically. I think it was David Kamka.
Oh, I've taken
This
that.
side.
Yeah, so those submissions should be rejected. Then, Your Worship, I want to clarify one fundamental point, which and now I'm going to the affidavit. So I'm going to the affidavit of Nakiranda.
Yes.
And I make one clarification on one point. The contention here is on two documents. We have an electoral document that is a PR form, which is an election document.
The other form.
The PR form is an election document, Your Worship. And we have someone calling herself Matrona Margaret, who signed on it as the first respondent agent.
Objection, Your Honor.
I'm coming to that.
Okay, you first listen to the objection.
Your Honor, this court made a ruling on that matter.
I'm responding to this of PR from which council.
No, the ruling I even went ahead and compared. The ruling was on the comparison and
I'm coming to that.
yes.
So I hope council is not taking us in that direction. We are ruling
Okay,
as-
let
No,
us
I'm not
listen.
coming to the national ID.
Okay, go on.
So, the comparison in issue here, and which court should focus upon, is the signature on the PR form and the signature on the affidavit of Nakranda Margaret. In light of the question of identity. Your Worship, the Russian president I sent in the case of Muyanja Simon Mutai means applicable. So that is the area of comparison which we are maintaining.
The one you raised.
Yes, Your Worship. And still, Council David Kamuka raised an issue that the signature is on a brief R form which is inadmissible. And he cited the case of the Supreme Court of John Baptist Kapoza. Your Worship, it appears my land friend only read the decision, the legal judgment of Justice Kanyama. But when we do that judgment, the sweet justice that is Murenga, Ogoch, and Katrel specifically discuss the issue of admission of non-certified DR forms in election-related matters. Your Worship, the proper position regarding admission of non-certified DR forms was discussed by three justices in the case of John Baptist Kapoza.
In the case of?
Yes. In the case of John Baptist Kapoza, versus Election Commission
As versus EC.
versus Electoral Commission and the answer. And the Supreme Court majority justices unanimously held that where the applicant or petition has made a request for certified copies from the Electoral Commission, or notified the Electoral Commission that he or she intends to rely on certain election documents. But the Electoral Commission has not availed certified copies.
Yes.
Then the applicant is entitled to rely on non-certified election documents.
On none.
On the non-certified election documents. Your worship, that position has been emphasized by the Court of Appeal. In the case of Bantalib Isa Talibola, versus Electoral Commission as the current position regarding admission of
Now, this case of John Baptist Kapoza, you've not given me the citation.
Your worship, it is the Supreme Court, election appeal number 11 of 2007.
Number 11 of.
Of 2007. And your worship, the Court of Appeal has ceased for that legal position as discussed by the majority justices in that case. I will cite only one case, that is Bantalib Isa Talibola.
Okay, the principle is clear, but practically.
Now I'm coming to the application. You ask when you look at our application, we wrote to the Electoral Commission, that is the applicant is Annex that is Annex Church. The applicant is after the support. Informing the Electoral Commission. And notifying it that copies of the BR forms will be used in this dispute. You submit therefore that the
Was it received?
yes, your worship, it was to be received by the Electoral Commission.
Okay.
Most important, in the paragraph 4 of the first respondent is after the reply, the first respondent does not dispute. The first respondent does not dispute the authenticity of the other form attached to the application. It is paragraph 5, Your Worship.
Mhm.
It is paragraph 5 of the first exponent is affidavit in reply. Paragraph 5 of the first respondent is affidavit in reply. The first respondent does not dispute the authenticity of the other form.
Okay.
Equally, the second and third respondents who are represented by their counsel before this honorable court
Mm.
do not dispute the authenticity of the other form before this honorable court. You therefore submit that the other form is properly and competently before this honorable court.
Okay, I've taken note of that.
We reiterate our earlier objections
Mm.
and pray that these affidavits are competent before this one. Let your worship permit to make a disclaimer.
Mm.
On this paragraph 5 of the electronic evidence, you have observed other points of view regarding this paper because from the fact that they want to make an application, so we can't use before they make if at all they want,
Okay.
depending on the court outcome.
Okay. Is that all?
That's what.
Okay. Is he, they made an allegation that your office received. Is it true?
Your Honor, this document was received on the 10th. According to, look at the document, because I have just looked at it here. And
Is it authentic? Is
it was received on 10th. I cannot confirm. I need to consult because
Or can you dispute the DRA form?
the issue of the DRA form. Your Honor, we can look at it. Your Honor. We can look at
You're
it.
not sure?
We can look at it because
Okay. Fine. Let me hear the POs from the first respondent.
Thank you very much, Your Honor. Your Honor, our first preliminary objection is premised on sections 73 and 74 of the Parliamentary Elections Act
73?
and 74 of the Parliamentary Elections Act.
Okay.
Your Honor, we want to submit that this particular application was brought prematurely
Okay.
for this honorable court and is an afterthought. Your Honor, Section 73 of the Parliamentary Elections Act enjoins a candidate to apply for mandatory recount. And Your Honor, we want to submit that the applicants did not invoke.
Where are they supposed to apply for the mandatory account?
Your Honor, the application is supposed to be to the returning officer.
Okay.
It should be in writing by a candidate or their agent.
Okay.
And there should be written notice of the intention to recount to all interested parties. To all interested parties. Your Honor, we submit that the applicant never invoked the provisions of this section. And instead decided to rush to this honorable court for an application under section 74. For an application under section 74. Your Honor, by failing to apply for a mandatory recount and seeking for a recount before this honorable court is, with due respect, an affront to the law. An affront to the law. Your Honor, the applicant lost the opportunity of a mandatory recount and cannot seek redress before this honorable court. Your Honor, where the law provides for a procedure to be followed to seek redress, that procedure must be exhausted before seeking recourse to another procedure. Your Honor, we are fortified in our argument by the case of the Speaker of the National Assembly versus Karume. It is 2008, Volume 1, Kenya Law Reports, at page 425.
420?
425.
Okay.
Where, Your Honor, it was held that where there is a clear procedure for the redress of any particular grievance, prescribed by statute prescribed by statute or constitution or an act of parliament that procedure should be strictly followed. Your Honor, in a similar case of Geoffrey Muthinja,
Still Kenya.
yes,
Okay.
yes,
Same principle?
same principle.
Okay. I will keep this one.
Okay. So, Your Honor, we therefore submit.
Okay. Yes?
I am abandoning this because it initiates.
No, go ahead. Go ahead with the submission.
I go ahead with the yes.
No. This one is enough.
Okay.
This one is
Your Honor, we therefore submit
Mm.
that this application is an afterthought, an abuse of court process, and ought to be dismissed with the costs.
Okay.
Your Honor, the second objection relates to the grounds for a recount. Your Honor, Section 74, under which this application is premised, does not state grounds for a recount. However, case law, in a plethora of authorities, has guided.
Also, to remind you, we are talking about points of law, not points of fact.
Yes, Your Honor, and I'm talking about case law.
Okay.
I'm talking about case law, which has been flouted.
Go ahead.
Yes,
Mm.
yes, I'm talking about case law.
Mm.
Yes.
Okay.
Your Honor, case law
Mm.
is pregnant. Case law is pregnant.
Huh?
Case law is pregnant with what court considers in a vote recount. Your Honor, I want to specifically refer you to the case of Kamba Saleh versus Namuyangu Jennifer Vyakatonda. Namuyangu
Yangu.
Jennifer
Mm.
Vyakatonda. Namuyangu Jennifer Vyakatonda.
Mm.
It is High Court Civil Appeal number 19 of 2011. Justice Stephen Musota, as he then was, had this to say, Your Honor, that court, that is on the last page. The last page.
That court?
That court, court cannot be called upon to scrutinize all the votes cast. All the votes cast in favor of candidates which is in tens of thousands, which is in tens of thousands, which is in tens of thousands. Nor can it go into the ballot boxes. Nor can it go into the ballot boxes on a hunting expedition. On a hunting expedition. In the hope that it will chance on ballot papers. In the hope that it will chance on ballot papers in favor of the applicant. In favor of the applicant, but we are not counted as hers. We are not counted as hers. Your Honor, this particular case law is in parliamentaria with this application, and specifically the affidavit in support of the notice of motion by the applicant.
You have an objection?
Yes.
Okay, just a little bit.
I really don't want to interrupt my colleagues, but my solution is, my intention is
Maybe he has not yet, he's laying a foundation for this. Let us give him a benefit of the doubt.
yeah, because the point of law is premised on the condition that all.
Okay, like I have ruled, let us give him a benefit of the doubt to finish up with what he's raising. Because I also want to appreciate first.
Your Honor, for the benefit of this court, there is a tendency for counsel to construe points of law as only statute or legislation. When we are talking about...
No, just proceed with your point of view.
Okay,
Yes,
okay.
proceed.
So, and I have cited case law. I have cited case law to buttress my point.
Okay.
And Your Honor, I am looking at the affidavit of the applicant, Ampaire Diana. And Your Honor, paragraph 7 of that of the affidavit says that I know that during counting, a big number of votes cast in my favor were wrongly recorded in favor of the first respondent. A big number. Then, he goes on to say, that a big number of votes cast were wrongly recorded in favor of the respondent. A big number. And case law is very clear on such unspecified numbers. Were wrongly recorded in favor of the first respondent, resulting into the first respondent getting more votes than I. Your Honor, paragraph 14 says that I know the recount will enable rectification of all the irregularities and the electorate to be represented by the leader of their choice. This is outside the purview, Your Honor. The courts have said this is outside the purview of an application for recount. This is strictly a matter for a petition. Your Honor, paragraph 15 of the same affidavit of the applicant says that I further believe, and I'm glad the word believe is being used here, given our early argument by counsel of the applicants, that I further believe that a recount of the votes will show that the votes in my favor were much more than those of the first respondent, and that I was the overall winner of the election for the position of female youth representative in the parliament held on 6th February 2026 at Hoima City Stadium. Your Honor, as I have submitted, this case law has clearly guided on what constitutes an application for a recount. It cannot be a hunting expedition on the hope that ballot papers in favor of the applicant will be found. Finally, Your Honor, we submit that the grounds again set out in this application are at variance with what the courts have stated. Is at variance with what the courts have stated.
Set out in the entire application or the affidavit? Or
the application and the accompanying affidavits.
all of them?
Yes. The grounds therein for a recount are at variance with what the courts have generally stated. Specifically, numerical questions. Numerical questions. Your Honor, case law has been very specific that a recount should be based on numerical questions and not anything beyond that. We therefore submit, Your Honor, that this application offends the provisions of both case law and statute, and it ought to be dismissed. Your Honor, I will invite my learned brother Kamkama to take it from there.
Okay, this is counsel.
David Kamkama, Your Worship.
Yeah, come.
Kamkama,
Come.
Your Worship, yes.
Go on.
Your Worship, I will start by tracing the point of my own brother has just been on. Your Worship, when you go to paragraph 4,
Maybe let me just a little bit, let me first get him well. Can you address me on the impact of your submission? So what do you want her to do? You left that hanging for me.
No, Your Honor actually said that because this application and accompanying affidavits offend both statute and case law, it should be dismissed with the costs.
Okay.
Yes.
Okay, thank you.
Your Worship, I'll go straight to paragraph 4 of the affidavit. Evidence, son, but you have queries.
Affidavit of?
You have queries. You have queries in paragraph 4. He states that according to me, the results I counted showed that the applicant had over 230 votes. And the respondent had less votes. Worship, looking at paragraph 1 of the said affidavit, Tiago Collins was an official polling agent of the applicant. Your Worship, a prudent agent cannot choose to count numbers of his own candidate and leave out numbers of other candidates.
I want to know which point of reason.
Just sit down, I'm going to bring it up.
Okay, now good enough. The duty we have is they have their right to interpret or to argue what they think is a point of law.
Yes.
Okay.
So, Your Worship, it's in line with the
So you're saying he ought to have he only recorded the figures for his candidate.
Yes.
Leaving out.
which is clear that he sat down, created a number, gave it to his candidate, and did not come up with numbers for the other three candidates.
Okay.
Your Worship, that is, this affidavit becomes offensive, that allegation becomes offensive on two limbs. One, it does not discuss the requirement of numerical questions which are comparative in nature, but also offends the rules of evidence as the contents of affidavits.
Offense the rule of evidence.
As the contents of affidavits. Your Worship, we submit that that's a material falsehood that goes the root of the case, and in line with the earlier case of Rutuk Francis, which was earlier submitted. Worship, in that case, Land Justice of Court of Appeal distinguished between material falsehood and falsehood that can be left out, and the consequences of material falsehood. Is that once that material falsehood is removed from the affidavit, the affidavit alone cannot stand, and the consequence of it is that such affidavit would be struck out, and we rely on that authority again, particularly at page 11.
So the authority is basically summarizing the implication of the material
Falsehood, yes. The case of Tuku Francis versus Elfas Ndamaje,
case of,
Rutuk Francis,
pardon?
Rutuk Francis,
Rutuku
Francis,
Francis
verse Elfas Ndamaje, Supra,
versus
Elfas Ndamaje,
Elifasi
Ndamaje,
Ndamaje.
Supra. I already quoted it, Your Worship.
Okay. Discusses
The issue of the effect of material falsehoods that got the substance of the affidavit.
okay.
Mm.
Material of
Falsehoods in affidavit. And Your Worship, the case of Kambasar, which my own brother had talked about, he did not submit a copy, but he also record.
okay.
Then, Your Worship, my own brother talked about the issue of not applying for mandatory recount. Your Worship, in buttressing it, I'm aware that there is annexure F. They have to have in support of the application, signed by the applicant. Your Worship, that annexure, which my own brothers seek to rely on, as being an application for mandatory recount, is not received by any office. Therefore, Your Worship is of no evidential value, since it is a convenient creation by the applicant and does not satisfy the requirements of Section 73 of Parliamentary Elections Act.
Okay.
Your Worship, it also takes me to Section 67 of the Parliamentary Elections Act. Your Worship, the applicant makes allegations under paragraph 9 of affidavit in support that she made a complaint which was ignored.
You had cited section 67.
Your Worship, under Section 67, it sets circumstances where a complaint is raised during counting and gives a mode, Your Worship. Your Worship,
Okay.
it gives a procedure how it can be raised and what should be done.
Okay.
And there is no record that the same was done,
Okay.
Your Worship. So, Worship, so these are just ramped up afterthoughts that this court should not entertain. Your Worship, then I got section 73, section 74, subsection 3, the Parliamentary Elections Act.
74.3.
Yes. Your Worship, it's mandatory that an applicant to recount must furnish security for costs. Your Worship, while Worship, the applicant under paragraph 12 states that she has furnished security for costs. But no copy of the receipt or even the evidence is furnished to that effect. And Your Worship, in the case of Namiyangu, of Kabasa and Namiyangu, which you have already quoted earlier on, it is very clear on it.
Okay.
Then, Your Worship, I got the affidavit to rejoin Your Worship, filed in court today.
Pardon?
Your Worship, I'm looking at the affidavit to rejoin filed in court today.
Okay.
Your Worship, there is something interesting here. Either there is forgery on the main application or there is forgery on the affidavit rejoinder. The affidavit supporting the main application, as one from Kampala, for a commission of oaths by the names of ambassadors. Your Worship, also the affidavit rejoinder, which is sold in Hoima, is commissioned by the same ambassadors.
So you're saying the affidavit?
The affidavits supporting the application,
Both of them?
yes, we are commissioned for ambassadors at Kampala.
Yes, one. Before?
A commission of oaths by the names of ambassadors.
Dennis.
Yeah, on 10th of February 2026 at Kampala.
On the 10th?
10th of February at Kampala. Now, Your Worship, the affidavit rejoinder filed in court today and sown today in Hoima.
Agenda was fun today.
Yes, 13th of February 2026. And sown at Hoima.
It was fun at Hoima.
Yes, sown at Hoima, Your Worship. It is for the same commissioner for us.
That is the rejoinder.
Yes, the rejoinder is sown at Hoima today. Again, before the said ambassador Dennis.
Basa.
Dennis. And Your Worship, I'm not an expert
Okay.
on documents. I want court to look at both signatures of the same commission of oath. The one of Kampala and the one that was made today.
Okay. No, first make your submission.
Your Worship.
What is wrong with them?
The signature for the commissioner for oath is different
The one of Kampala is
and the
different from
one of Hoima.
that is Basa.
Yes, Ambassador Dennis. Worship, this anomaly goes the root of the application.
Okay, let me also look at it. No, don't remove. Okay, you can remove from
That left in support of the application and the one you rejoin. Your Worship, this is a classic example of forgery. It leads to one or two things. It's possible the commissioning stamp of the ambassadors was forged. Two,
So which signature do you detect was forged?
right now, court is unsafe.
No, to you, which one was forged?
Your Worship, it's possible the one for the application was forged.
The application was forged.
The one for the application was forged.
Okay.
Because now we don't know the address of Mbasa. He is either from Poto or is either from of Kampala.
Okay.
Or he was not anywhere. Possible both of them were forged. Then two, that the deponents never appeared before the Commission of Oath.
It appeared before.
Never appeared before a commissioner for oath. Your Worship, based on the earlier case of the one we have just read on of Ndamaje, of Ruth Francis, versus Elfas Ndamaje. It goes on to address issues of
Yes, of
Elfas, Ruth Francis,
Otuku.
Ruth Francis,
Otuku.
versus Elfas Ndamaje. Where
Which page?
page 13. So page 11, Your Worship. Page 11. An affidavit. Here, an affidavit with the forged jurat was struck out.
Okay.
Your Worship, where there is suspicion about the Commission of Oath, the only safe way is to strike out the application unless the Commission of Oath appears in court to clarify that issue. And Your Worship, we pray that this application is struck out for being based on forgery of the Commissioner for Oath. And Your Worship, once the affidavits are struck out, the application will remain unsupported, and the only fate can suffer is to be struck out. We so pray.
Okay. You also have your PO?
Yes, very, very briefly. This one. Your Honor, Kayonda Abubeka, for the second and third respondents. Your Honor, this application is incompetent. For the reason that it generally offends the intention of section 74, read together with the authority of Kambasale as cited by Senior Counsel Basari Asuman, which emphasizes the issue of this court's jurisdiction. This court's jurisdiction to settle a dispute relating to numerical questions. Your Honor, the applicant attempts to show that she did not win. Attempts to show that she did not win. And then she, under that attachment of Annexure F to the application,
She attempts to show that she did not win.
she attempts to show that she did not win, but her victory was robbed. But her victory was robbed. Your Honor, and in a purported objection, Annexure F to the application, that objection does not comply in any way with the requirements of the law.
Which objection?
That she objected, she said request for a recount. She says she requests for a recount. And she states here that announced, and this raised the doubt regarding.
Because remember, you're raising a point of law. What is the point of law?
Yes, Your Honor, my point of law is that this document, this annexure, offends section 67. 67 of the Parliamentary Elections Act, which sets a procedure of objection. That if you are raising a numerical question, you must be specific on the numbers. And section 67 is providing that where there is counting, where the
Which
process...
annexure is that? You're referring to?
Annexure F.
What does it talk about?
The Annexure F is purportedly written to the returning officer requesting for a recount.
So you say that annexure offends which provision of the law?
We are saying this annexure offends section 67 when it in itself does not specify the exact ballots, the exact figures that were that she was robbed of.
So you're saying the request, which is annexure.
Annexure F.
Annexure F.
To the application. Annexure F to the affidavit.
Offense.
It offends. It offends section 67 of the Parliamentary Elections Act. in as far as it does not state any specific numerical issues. Any specific numerical issues.
What does that provision provide? 67?
Your Honor, the provision provides that a candidate or an agent of a candidate or any voter present may raise any objection during the counting of the votes. And each presiding officer shall, it states, keep record of those objections, of every objections that are raised. And it states that any voter, it states that every objection made by any candidate or an agent stated above to any ballot paper found in the ballot box, that objection should be pointing to a particular ballot paper in the box. And then, if this
Annexure
objection,
F, was it Annexure F about
it's a request.
a request for a mandatory recount?
Yes.
So I thought you would tell me either there is a procedure for...
I'm coming there.
Request.
I'm
Okay.
coming there.
Okay. Maybe try to get there.
Yes, I'm getting there.
Oh, that's what you
My submission is, if you are complaining, you are requesting for a recount, you state that during the process of counting, this particular ballot paper was considered invalid while it is supposed to be valid. And even the law here states that that objection should be recorded. And
But the section you're quoting, is it one for a recount or
yes, it states about a recount, subsection 3. Subsection 3 states that after any objections, the decision of the presiding officer in respect of one objection raised above is final, subject to reversal only on recount. Which means when you are going for a recount, you get there.
Which means?
The applicant should state that during the process of the counting, this ballot paper, this one, this
State
one.
in the application
Yes,
for
it
recount.
should be pleaded.
In the request for a recount.
It should be pleaded both in the request and even in the application.
For recount.
Yes, for a recount.
Before a returning officer.
No, in both, even before court. Because here the law says that that objection is subject to reversal on recount.
Let me look at the provision, maybe. I will appreciate it more.
Section 67, subsection.
Because the section you're referring to, the heading of it says complaints during counting of votes.
Yes, Your Honor.
And here we are talking about a recount after the counting, not during.
Your Honor, we are saying
Because
the case of Kambasari.
The annexure we've been referring to.
That annexure which request for a recount of votes. That annexure.
Yet, because for example, my thinking was, your 67 you have cited is what is happening during the counting of votes.
Yes, Your Honor.
Then now we have section 73 after the declaration of votes.
Yes, Your Honor. What my argument is, first of all, in this request, you must state, because you have been present during the process.
So 60, sorry, which section is that?
67 subsections.
No, you leave 67. I'm looking at the mandatory recount.
74.
73.
73. 73 is a mandatory.
Because now the annexure F is basically section 73.
Much obliged. What we are saying in 73, if during the process of counting you had objections, for it to be entertained by the returning officer, you must be specific. Why? Because the recount should not be merely on a fishing expedition. shouldn't be mere on a fishing expedition. It should state that there are these 4, there are these 5, there are these 20, there are these 30, which have been objected to. I want them to be recounted by the returning officer. And the returning officer should go for those specifically.
So basically you're saying even before you start complaining here or have a mandatory
Even before you start
you
complaining.
must have started with 67.
Yes, you must have started with 67 to show court that you are not on a fishing expedition.
Okay, let me appreciate 67. Now, you don't make noise.
Yes.
People are making noise because there's a noise. So let me ask, is it mandatory under 67?
Your Honor, our argument is...
No, wait, first address that.
Yes.
Is it mandatory that whenever you have issues during or conflicts during counting, you must raise them?
Yes, Your Honor, because the law states here that shall.
Are you sure?
The law says the returning officer shall keep the record.
No, I mean the candidate or the agent raising the complaint. Is it mandatory that...
It is not mandatory, but it points to the interest of justice. That if you want to be guided, if you want to...
So if it is not mandatory, would you raise it as a point of law to say, because you did not do this there?
In a sense that case law, because points of law are not points in the statute only, even in
No, I
case...
have no problem. I have no problem.
And my argument is...
Are you saying there is a case that says if you have not commenced, you have not...
No, the case of Kambasare is talking about a fishing expedition. That's the application for a recount should not be based on...
Actually, I was going to buy your idea if it was mandatory that you must raise it. And because the application is silent about raising it, then would assume she did not raise.
But the authority...
67.
But the authority, Your Honor, of Kambasare is on the issue of the applicant should not be on a fishing expedition. And we are saying this is a process.
Now the challenge I have with 67, it is optional. You have the option of raising or not raising.
Maybe you are on. 67 is not mandatory.
Off record.
Yes, off record, because it is this time. 67 is not mandatory. But if you choose to
To do what?
follow through a mandatory cover,
73 and
yes,
74.
if you choose to, you must follow what 67 is talking about. Otherwise, it is not mandatory. But if you choose to, then it has to flow, to borrow the words of my learned brother. It has to flow from 67 to 73. But it is true, it's not mandatory. That's why, Your Honor, after 67, the subsequent paragraphs are couched in mandatory terms. Okay? The presiding officer shall keep a record, blah, blah, blah. Every objection shall be numbered, blah, blah, blah. So it is not disjunctive, it is conjunctive. So if you are talking
Now
about...
let me ask, are you telling me for 73 to be applied, you must have reasons? Can't you apply without any reasons for 73?
Your Honor, the reasons
Off
must,
record.
the reasons must be
No,
there.
I mean, even if you say not to give reasons, should you give reasons?
But the reasons must be there because, Your Honor, first of all, there is a margin difference. So if there is no difference in margin, you cannot apply.
No, my simple question is,
Yes.
if the margin we are assuming is less than or 50 and below, do you need to give reasons for mandatory?
You see, you have to, Your Honor, for one simple reason.
Which provision? Read 73. Does it talk of reasons?
No, that's why I'm saying, I'm flowing from 67.
Yes. You
Yes.
have 67 in
Yes.
mind. Now we have 73 that is telling you apply for mandatory.
Yes, because on what basis would then you be applying for?
That's why I'm asking for
Yes.
73. Do you need to give reasons? For example,
Mhm.
is the returning officer having discretion to say yes or no? I'm not going to allow or I will allow for ABCD reasons. If you're within the 50 mark, 50 and below,
Mhm.
you need to give reasons. Is the returning officer having discretion to say I allow or I disallow, depending on the reasons?
Your Honor, you have to, you need to.
So if you don't give reasons, is the returning officer having the discretion to throw out the application for mandatory?
Yes, it retains that discretion.
Then what is mandatory? What is the meaning of mandatory?
No, mandatory, Your Honor, it is in the sense that once you are dissatisfied with the entire process from 67, then it gives you that way. Mandatory, in effect, is saying administratively do it here. You don't have to go to court. That's the window which is
I
being
thought mandatory means you have no discretion.
Sorry?
Mandatory basically means there is no discretion. Like the way we talk about mandatory pay.
Your Honor.
Okay, now, back
Actually, you
let me put him on.
your mandatory pay,
No,
now
no.
we have seen what it's
No, no,
not
no,
mandatory, it's not mandatory.
Your
It has
Honor,
been a bit
we don't go
different.
there. Your Honor,
Okay.
my argument on this mandatory, the law states here that we are after the official addition of the votes.
Okay, basically,
That
I was
means there is
raising
a
that.
reason.
You wait. I was interesting myself in the same to appreciate whether in itself it will become a point of law. Because you see, the reasons you're raising are good reasons, but the question is, will they apply in a point of law or they would come during the substantive application? Like I should be fair with you, I listened to their submissions. I wanted to interject, but I gave them the benefit of the doubt. But my biggest challenge is if we keep on raising points of fact, we shall basically argue the application, you get me, on points of, under the disguise of point of law. And now it would be very unfortunate that the time we would have taken to argue the points of facts, we are utilizing it on points of law, disguised as points of fact. Because now let me ask another question. For example, if I overrule, I don't find them to be points of law, are you going to raise the same arguments again when we are handling the substantive application?
Your Honor, they may not be the same.
But I will not
They may not be
preempt
the
you.
same.
I will not preempt you.
And
Go ahead. Let me
Your
put you on
Honor,
paper.
our argument is,
So basically, you're saying that anybody who is supposed to apply for a mandatory recount under 73 or a recount before a chief magistrate under 74 must have
raise
complied with the 67.
must raise numerical issues.
Not complying with the 67.
No. Because it is part
Because
of
it is you who had raised 67.
Yes, I brought in 67 in the argument that if it is not a fishing expedition, like the case of Kambasari states, then you must show that you attempted.
That's why I'm saying, if I'm to simplify that, would I be right to say your argument is that if you're going to do a recount under 73 or a count under 74,
Yes.
you must have complied with section 67.
Yes. Under subsection 3. It may not be as of, it may not be, you can have an option. You can have an option, either to follow or not. But we are saying that for you to demonstrate to this court that you are complying,
That mandatory, because
you are
the point of
complying.
law, the way I appreciate a point of law, it is don't do this or do it this way.
Your Honor, if a particular section is offended, I don't know whether all the sections that have to be offended have to be mandatory. That's my challenge.
Okay.
If you don't, if the section is
But
not
now let me
mandatory-
get you well. Make yourself clear. I'm putting you on record.
Yes.
You can raise the point of law again.
My point of law
In simple terms,
in simple terms, is an application for a recount is by law supposed to be based on numerical disputes. numerical disputes. Your Honor,
Yes.
on numerical disputes.
Okay.
The numerical dispute
Mm.
may emanate from the point of counting. They emanate from the point of
Which disputes made emanate from
the point of counting.
mm.
The votes cast. The votes cast.
Okay.
And section 67.
Mm.
Section 67, subsection 3.
Mm.
Section 67,
3.
subsection 3
Mm.
creates
Yes.
creates a situation.
Mm.
Creates a situation where a court conducting a recount
Mm.
conducting a recount may reverse the decisions or confirm them, may confirm or reverse the decisions
Mm.
made during the counting process. Made during the counting process.
Okay.
Our argument is that non-compliance
Mm. Mhm.
with that
Yes.
procedure, non-compliance with that procedure,
What procedure?
the procedure of identifying
Mm.
the valid or invalid votes in favor of a candidate
Mm.
provided for under subsection 267, subsection 2.
Mm.
If that
Okay.
procedure is not non-compliance with that procedure,
67 too. Yes.
67.2,
Mm.
persuades this court
Mm. Mhm.
to impute a fishing expedition. Which the case of Kamba Saleh, cited above by my learned brother,
Mm.
seeks to reject if this application is to be justly considered. If this application is justly to be considered.
Okay.
Your Honor, I associate myself with the earlier submissions of counsel for the first respondent entirely.
Okay.
In addition to my own
Okay.
objection raised, and invite this court to humbly dismiss this application.
Mm.
With the court
Summarily.
Yes. With
Okay.
court.
Okay.
I
Uh-huh. Let me hear from
Please, Your Worship,
mm,
Cook of Ryan. Your Worship, I will address part of the objections raised, and then my colleague will summarize at the end. Your Worship, I will, in response to all the objections. Our submission is that they are not preliminary points of law. And I rely on the case of Mokisa Biscuit. Mokisa Biscuit Manufacturing Company Limited. Versus West End Distributors Limited. Reported in 1969. Volume 1, East Africa, at page 696.
696.
696.
Okay.
In that case, the court ably defined what amounts to a preliminary on law, a preliminary objection. And I will paraphrase that it is that objection
Are you going to give court a copy?
you were ambushed with these objections.
Okay, go ahead.
But that decision is cited in several cases.
Okay, go ahead. Go ahead.
And it's available online on the platform. Your Worship, a point of law is argued on the assumption that all the facts pleaded by the other side are correct. And it cannot be raised if any fact has to be ascertained from the record and the evidence. The arguments of that the application is a fishing expedition, that the application did not comply factually with, because they refer to Annexure F, all that requires the court to look into the evidence. So to that extent, those are not preliminary points of law. And we invite the court to disregard them on that account. Because the effect would be to deal with the evidence on record, analyze, and make a finding. You should now specifically, that was a general response, I will specifically deal with the objection that the application is premature. And council relied on sections 73 and 74.
That Council Basarilo?
Yes, Your Worship. Your Worship, sections 73 and 74 are different. They provide two different mechanisms.
But did he say it was premature?
Yes. See,
That would first go there, then come here? Or you seem to say your failure for the applicant to apply for the mandatory recount seemed to waive a right to go in for 74. Council, was that
Yes.
Yes, and the prematurity is that you should have gone there first and come.
No, it seems to say your failure to apply for mandatory seems to waive away your right to even seek justice within 74.
Yes, Your Worship. And my submission on that is that that is not the correct position. suppose the recount under section 73 is after official addition. You apply for that recount after the addition of votes.
Yes.
And Your Worship, the applicant applied for the mandatory recount. That's according to para 10 of the affidavit in support. That before declaration of results, the applicant requested for a recount, but the same was denied by the returning officer. Para 10 Your Worship should be read together with Annex here. So Your Worship, our submission on that is that the applicant applied for that mandatory account and the same was denied.
Okay.
Your Worship, the second point on that is that this request for a recount to the returning officer is not denied or controverted by the third respondent to whom the request was made. The request for the recount is not specifically controverted by the third respondent. Because she has no affidavit before. Then there was also a submission that if you don't proceed under 73, you can't proceed under 74. And I have already made, and then there was also the question of whether it's mandatory or discretionary. And our submission on that is that section 73 is discretionary. I beg your pardon, section 73 is mandatory, it's not discretionary. Is mandatory, section 73. The third respondent is compulsorily directed by this section to conduct a recount if the following conditions are met, and they are provided for. Where there is an equality of votes between two or more candidates, or where the number of votes separating.
Okay, what you must know is that that area came in when you were trying to appreciate section 67.
Yes, Your Worship.
Yeah, so if you're making a response, I want to know you're addressing which point of law that was raised.
Your Worship, I'm still addressing the point of law of saying that we should have sold 73 first before coming.
Okay, you see, originally it seemed to suggest that for you to go in for 73 and 74, 67 must come in first.
Your Worship, let me
That
address
is,
that.
that is what he was trying to say. Then he coupled the same with a numerical strength.
Yes, Your Worship. Your Worship, let me address now 67. Your Worship, now 67 is totally cited out of context. Because those are complaints that are raised during counting. This is different from 73. After addition, here they are still counting, but you have a complaint during the counting. Then 73, after the addition, then now you have
Maybe
a complaint for recount.
they seem to just question and say, if you surely had complaints that are genuine, even before you seek redress under 73 and 74, you start with 67, because 67, during the process, speak up at that point and raise your complaints. So they seem to say, by you failing to point out your grievances at the earliest opportunity, it would mean you're doing a fishing expedition. But like I say, that argument would suit well during, that is where you may have a problem. Because I would feel bad when you're going to repeat the same submissions.
Actually, the
You get
applicant,
it in samples. You get me?
we are pushed in those circles
Yes.
by the respondents. Your Worship, actually, the applicant complied with section 67. And I made the court to look at paragraph 9 of the affidavit in support.
So you're saying the applicant
Also complied with that section.
What does paragraph 9 say?
Paragraph 9 reads that during the counting process, my polling agents and I complained of the irregular conduct in which the presiding officer was counting the votes, but the complaints were ignored.
Okay.
And this section 67, these complaints are now addressed to.
So you're referring me to paragraph?
I'm referring you to paragraph 9.
Okay, I've taken note. You can get to another matter. The other-
Your Worship, now,
Okay,
yes.
go ahead.
Your Worship, there was also a submission made to section 74. Your Worship, section 74 now is invoked after the declaration by the returning officer. There could have been mandatory recount or not.
Maybe their submission on 74 was to the effect that your application was not having preferably what I would call a cause of action,
The numerical,
on the ground that it did not disclose the numerical strength or differences. Basically, that's what they were submitting on 74. Because they seem to say 74 is silent on the grounds for a recount under 74. So they cited case law, that is the case of Sarekamba. They say the application does not meet the requirements in Kamba to do it numerical strength.
Your Worship, Your Worship, that is not correct.
Okay.
This application, in its grounds and all the supporting affidavits, raises matters on how the counting was conducted.
They refer it to the affidavit of the applicant.
Your Worship, let me start with the grounds.
Because for the affidavit of the applicant, basically they were saying it never mentioned any figures, numericals or numbers was just basically talking about how she won, how her votes were given to the first respondent without pointing out numericals.
Your Worship, Section 73 does not require.
We are talking about 74.
74, I beg your pardon. Section 74 does not require that the applicant must state.
Okay, like I said, that was clear. He said 74 is silent about the grounds, but case law expounded on the same. So he referred you to the case of Saleh.
Yes, Your Worship.
So basically, it seems to say, if you're responding to that, respond to the finding in Kamba. That was pointing out the grounds for.
Your Worship, during the counting process, recording one's ballot paper as that of the other candidate goes to the numbers of the counting.
Okay.
And by that, I'm referring the court to paragraphs.
So you repeat your submission? On
That-
numerical strength, you're saying?
During counting, the presiding officer's act of recording the applicant's votes as those of the first respondent
Yes.
points out the numerical inconsistency
Okay.
and the only remedy available is to recount. And I'm referring the court to paragraph 6.
Paragraph 6.
Paragraph 6, 7, and 8 of the affidavit in support.
With the application?
Yeah, of the application, the main affidavit.
Okay.
And paragraph 4,
So,
paragraph 4 of the affidavit of Tuliahewa Collins. You also, actually, paragraph 4 of that deponent states the numbers according to him,
okay.
what he counted.
Okay.
So, Your Worship, such an irregularity as pleaded cannot be a fishing expedition. The authority of Kamba Saleh, my land brother with friend will address it in detail.
Okay.
But the quick comment I can make is that it relates to general elections of directly elected members of parliament, the directly elected members of parliament, who are voted through a universal adult suffrage system. This particular election in dispute is by way of electoral college. It has a limited number of about 440 something delegates. A deponent like Tuyaheva Collins, who stood there and he's stating to the court that according to his counting, the applicant had more votes. According to his own counting, 230. 230 is enough material to prove to the court that this is not a fishing expedition. Unlike in Kamba, where one witness cannot depone to the counting of the entire district or constituency that has hundreds and hundreds of polling stations. This particular election is of a special nature. It has one polling station, one ballot box. The applicant who was standing there, together with the witness who's attaching a number of votes, is enough material for the court to find that this is not a fishing expedition.
No, but even Kamba basically was insisting you point out the numericals.
Yes.
And in that case, figures. And that is what you're doing. So
Yes.
I don't know why you're distinguishing Kamba from your facts.
You should.
Because you seem to distinguish Kamba from your facts, yet you have just told me how Collins mentioned numericals.
I'm saying two points, because I'm saying 2 points. That Kamba states the principle, which we
Of
agree with.
numericals.
Yes, which we agree with. And I'm saying the current application satisfies that principle. Okay? Then, I am also drawing a difference in terms of facts. The difference of the facts in Kamba, yes, the principle notwithstanding, but the...
Actually, here they were interested in the principle. Well, not even the facts, but the principle.
Yeah. So your logical submission is that we have this application satisfies the requirement of showing the numerical disparity arising from the counting process.
Okay. Are you talking about already?
Your Worship, then there was an objection to do with security for posts.
Maybe before you leave Collins, there was an argument, maybe, I don't know that it is going to be your colleague who will address it. And the argument was that his failure to state the scores of the other candidates was made that affidavit of Collins. Did you call it fraudulent? I don't know. Or defective? What exactly?
It was effective because it had deliberate falsehoods.
Okay, yes. Because now to him, he said the failure of the affidavit of Collins stating the scores of the other candidates made that paragraph a falsehood or a false statement. And for that matter, made the conclusions that the entire affidavit of Collins was a falsehood. And went on to say the case that says any falsehoods in an affidavit would lead the same to be struck out.
Your Worship, my colleague would comprehensively
Okay.
but my submission on that is that
No,
Collins-
leave it for your colleague, like you have suggested.
Your Worship, he will buttress it, but my simple
Okay.
submission on that, so that we don't lose the opportunity.
Okay.
My simple submission on that is that Collins depones that affidavit in his capacity as an agent of the applicant. From his affidavit, his role was to ensure and protect the vote for his principal, who was the applicant. For him, he has stated what he recorded, and his business there was entirely on the applicant's vote. So he cannot be faulted for not recording the first respondent's vote.
Okay. I'll take a note. Move on.
Just now moving on to security for hosts. Your Worship, in filing the application, the proof of payment of security for hosts was filed with court record. And I wish not to dwell on that. I invite the court to look at it.
Maybe their point was that you claimed in in the affidavit, it was claimed, but there was no evidence to the same effect. There was no attachment to accompany or to prove the claim.
Your Worship, the issue of furnishing security is not a matter for trial. It's a matter for the filing, propriety, and the regular filing of the application. If it's on court record, the applicant can state that he has furnished.
Like the video.
Your Worship, for the video, it's different. It's the video you were
Okay, that was a by the way.
Your Worship, I also took it as a by the way.
Yes.
But
I was only saying for the video, it is also on court record, although you don't have it.
what the applicant states in his affidavit that he furnished security is true because the receipt for that payment is on the court record.
Anyway, for a fact, we have it on the court record.
Your Worship, we need inspection. You see, a document in court, not something. Your Worship, for the record, a document which is in court, if it's been read by the applicant, then you see, I don't want to turn this court into a witness. This document should be furnished, we inspect it, and see whether it's an actual.
Okay.
And then one, of course, they are told us it is not attached to the affidavit, it's not there. So
Maybe
First the
it
document.
is just
Some
good
to your
practice that whatever you talk about you, because that's why they raised the PO, you are not seeing that evidence. And neither could the court disclose to them because it's not my role. It was you who was alleged to furnish the evidence. Okay, but go on.
Your Worship, I appreciate the court's guidance on the good practice. But Your Worship, the fact still remains that there is proof of payment, and we have no objection to the court availing that receipt. According to the National Payment Systems Act, the mode of payment.
No, the court was meant to retain a photocopy, you keep the original. That's you left the original with the court.
Yes, Your Worship, we are leaving the original with the court because the payment under the law, under the National Payment Systems Act, is verifiable because it's the URA payment system and the law is there on that.
And with us in our system, if you want to claim your money, you come with the original.
For another day.
Yeah, we can leave that. You can move on.
For another day.
Okay.
The applicant can even choose to donate it to the state. So then Your Worship, I will now move to
Your Worship, I'm seeking guidance. Once the applicant chooses not to disclose that receipt, as responsible thing that it's not there.
Okay, now the unfortunate or fortunate bit is that you're making raising the POs before court, and it is court that is going to make a ruling over the same. So yes, so I will address that matter.
Okay.
Your Worship, I want to.
You don't want court to make a ruling over that? I will make a ruling.
No, but Your Honor, we take your guidance in good faith, but for fairness,
It is prudent.
Yes,
I will ask.
yes,
I will ask the clerk, since it is on court record.
yes, to help us go
Yes.
through it.
So you go and make a photocopy and.
We make a rejoinder.
And Your Worship, we don't want to be a rule of court. There we don't want to go there, Your Worship. You see, it's like now God is saying we are witnesses, this is done.
No, but
An applicant, your worship, files and payment is evidence by receipt. And
now
your
you
worship,
see, what I'm trying to avoid is to take so much time on matters that look to be more direct. Eh? Because we need to, and my take is we must get to the main application. If the POs, for example, do not throw it out. Yes. So now, for example, if we start arguing on a receipt, it will take us the whole day here. Because I'm also aware of the time within which we're supposed to hear and dispose of this application, including if the account is, say, allowed, still within the same period of time. So, but I'll let her make a photocopy. So you move faster.
Most of that
Because we're supposed to make a rejoinder, then we go for lunch, then we do the ruling, and we see where we are heading to.
The last one was on commissioning. The
Commissioning, yes.
commissioner for all, the application being commissioned at Kampala, they have definitely enjoyed the commission at Hoima. Your worship, as an officer of course.
Now, for those making noise, it is a bad practice. Eh? Please, you don't make noise.
Your worship, the affidavits were properly commissioned. The affidavit in support was commissioned in Kampala. Your worship, we were given directions. We knew we had to file a rejoinder. We traveled with the commissioner for oath. The commissioner for oath, his contacts really are on that stamp.
Is he in court?
No, he left after the commission.
Okay.
We could not sustain
Fine.
paying him to stay here.
So you traveled with the commissioner for oath?
Yes, as an officer of court, then we traveled with Ambassador Dennis. The contacts are in his stamp, which is on court record.
Okay.
We really have respect for the court and have some standards. We are doing some practice.
Okay.
So I believe through the court, it's not a matter that our colleagues should have imputed without.
Okay.
But I will leave it at that.
Okay.
So, Your Worship, my land friend will now address you on the details on authorities, distinguishing them, and some facts.
Okay. So, Enoch?
Your worship, for the record, I start with the first objection relating to the application being premature.
No, they don't seem to say it is premature. You're only saying because you did not comply with you did not do the mandatory account, this one is incompetent now before court.
Much
Should be so now.
Your worship, a reading of section 74 of the Parliamentary Elections Act really shows that a prior application for mandatory recount is not a requirement.
What?
A prior application for mandatory recount
That is section 74.
is not one of the requirements
So
for
74.
for you to file an application for vote recount before Chief Magistrate Court.
Okay. Yes, go ahead.
Be that as it may, even if a mandatory vote recount application was to be found as a prerequisite, the current application clearly shows that the applicant, in her own handwriting, made a request for vote recount on the 6th of February 2026. And that letter is attached as Annexure F to her affidavit. Your Honor, the law does not require that you should prove that that EC duly received the application. All you need to show in your application is that you made an application. And in this particular case, she's showing that the application was ignored by the officials of the second respondent. So this becomes an issue of evaluation of evidence as to whether it is the applicant who is correct or it is the respondent's witnesses who are correct on that. So this is not a point of law. It becomes a point of law which is facts. So that issue ceases being a matter of law, but a matter of evaluation of evidence. So that point of law is misplaced. And I say so with due respect. It's my goodness.
Okay. Go on.
Secondly, Your Worship, there is a complaint from the respondents that this application does not disclose grounds for vote recount. Your Honor, I maintain that this application clearly discloses, more particularly in ground 4, ground 5.
Because affidavit?
I'm citing that is the notice of motion. The grounds when I'm coming to the affidavit, supporting those grounds. But when you look at ground 4 up to ground 6, those grounds are raising the questions to do with numericals. Because I'm coming to case law.
From the application?
Yes. Now, Your Worship, what is required in an application for vote recount?
Which paragraphs point to
That
numericals?
is paragraphs
3, 4,
4, 5, and 6
4,
of the notice of
5.
motion.
6.
Of the notice of motion. And these other affidavits are elaborating on those grounds.
Okay.
Your Worship, case law specifically in the case of Yanimawini, versus Yomangini, that is High Court in Barara Civil Division number 9 of 2001. The court guided on when a vote recount can be carried out. Specifically on page 6. On page 6 of that case, the court stated, among others,
Yes.
that the jurisdiction by the Chief Magistrate Court to carry out a vote recount is intended to be and is part of the segment of the counting of votes and the announcement of results. A recount of votes under Section 56 of the Act is merely a legal function performed under the neutrality of the courts and intended to untangle any numerical questions, and I put emphasis. So now, once in your application and evidence, you raise numerical questions, now the Chief Magistrate Court has the issue at that time. So when you look at these grounds are raising the matters to do with numerical questions. So we invite this one of the court on the basis of that authority to make a finding that this application raises numerical questions that allows for a vote recount.
Okay. I think you have exhausted it. Any pending?
No, I will go to the next point. Your Worship, regarding the question of council submission of the commissioner for both, his argument was that there is a possibility. Now, also for the not allowing speculations, conjecture. Bearing in mind that the commissioner's stamp has clearly indicated on the stamp, then you cannot start creating speculations that is a possibility of forgery. Also, we not aware of that question.
Now, he had invited the court to compare the signatures as well. And he seemed to conclude that they had a material contradiction.
Now, Your Worship, that question can only be answered by the commissioner for us, whom they had the chance of calling, but they have not utilized that chance. Exactly. Otherwise, now you cannot answer that question.
No, but you cited an authority. When you told me, the court, even if it is not the handwriting expert, can look at the signatures and get to a conclusion that they are forged. That in case that happens, the court should oblige to throw out such affidavits.
Your Honor, court can still go ahead and
No, I compared, but I wanted to know your response. Are they different? Are they the same from, or you have no response?
unfortunately, I have not seen it. Maybe I need to That is the original application.
Yes, Jordan, that has been support.
Your Worship, if the court is of the opinion that these signatures are different, there is room for verification because the commissioner put his or her contacts. Now, the challenge I had in the earlier case, counsel stated that even if the deponent was in court, but was not called in court to verify that issue.
But to you, are they totally different? Do they look alike?
To me, they look similar. According to me, they look similar.
Okay, go on, counsel. Any other issue you want to address?
So, Your Worship, our submission is that all the so-called points of law, these are not pure points of law. These are matters which require either interpreting how you apply a law to the facts or ascertaining who of the witnesses is a liar. So now that one goes for a normal hearing under order 6/18, whereby the applicant comes first, responding to the rejoinder, but not first raising them as points of law. So all of them should be rejected and
Okay.
the application is handled merits.
Okay. Council, do you want to rejoin or you're leaving it?
Yes.
for-
Yes.
Okay.
Just rejoin, Your Honor. Number one, Your
Try to
Honor.
be brief.
Yes.
To hit to the point.
Yes.
Highlight it.
On the authority cited by Mukisa Manufacturing Company, by my learned brother. Your Honor, once an application cites a provision of the law that has been offended, it suffices to be a preliminary point of law. It suffices to be a preliminary point of law. Number two, Your Honor, we submit and maintain that section 53 was never complied with.
53, 67,
73,
73.
yes, 73 was never complied with. It was flouted. Because, Your Honor, there is no evidence that has been adduced by the applicants